There comes a point when clients do want a pit bull. They want an attorney who is going to zealously advocate for them. And just because that's not the approach we're taking in the beginning doesn't mean that we can't flip that switch and go down that aggressive pit bull win, win, win in court mentality. What we do is we start every single case with two piles. Is this one that's going to litigation? And is this one that maybe can be solved pre-litigation? We work both cases up as if we were going to court tomorrow. May it be an event that ends up in court or could end up in court. We prepare for the possibility that we are going to end up in court. However, do we take this case as a conciliatory matter, trying to find a solution and work with the other side if you have two people who can work together? Or do we realize that the other person isn't going to work with us, or that we're never going to meet a common ground? And then we switch from a conciliatory type to more of a litigation style. And the litigation style is sometimes necessary. Sometimes you have to litigate. At the end of the day, there's a reason that there's the person in the robe that sits and listens and passes judgment on the facts, and they're there for a reason and they have a very important part. While 95% of all cases settle, there is still the 5% that don't. And for years and years and years, we strived on those 5% of cases. While we haven't turned our back on those 5% of cases, we realized over the years that there's a more cost-effective way, there's a more reliable way, and a more controlled way of controlling the outcome by trying to negotiate a settlement versus coming into court and litigating. And oftentimes, through solid, sound litigation, we can reach a settlement prior to trial and give or get the clients the result that they want. But we have no problem flipping that switch from conciliation to litigation. We try really hard to boil the issues down to their simplest form, to the most easy to understand, most reliable approach we can. We want to present the evidence in such a way that there's only one logical conclusion to the evidence we're presenting, and that's our position. To the point that it's almost ridiculous to think that there's another opinion or another side or another outcome, because our result that we're seeking is the best result, is the sound result. So we try to really boil down our positions to simplicity. And if we can keep it simple, it makes it really easy for clients to follow their truths and to find the solution that they want without having to really think about it. If we get too complicated, people think about it, they make mistakes, they get uncomfortable, and they don't make the right decisions. So we really try to just keep it as simple as possible and teach the clients how to bring it down to the root of what they want and to present that to either the other side, to a judge, to a jury, or through negotiations at the boardroom table and negotiating there. So we really try to keep it as simple as possible.